Nice to meet everybody. You're a restaurant owner and you appreciate the grave concern your business faces from a single lawsuit. Let me underscore that. One single lawsuit from one single employee making $8 an hour can wipe you out. And I just scratch my head. I speak weekly, I meet with restaurant owners weekly, and I just don't get it why restaurant owners won't go to their pockets for $3,000 or $4,000 to insure against the risk of being wiped out. The chances of you being sued by an individual employee is a hell of a lot greater than having your home burned down, but you wouldn't think twice about paying $500 or $1,000 for homeowners insurance. So I only have 20 minutes today to cover the 5 top lawsuits. So I'm going to try to briefly cover the 5 top lawsuits and make it worth your while that you chose to listen to me today and not eat some delicious food outside. And when I go over these 5 top lawsuits, try to give you some kernels that can help you protect against one single lawsuit. But no matter what I say, the most important person up here, it's not me today, it's not what any lawyer can tell you, it's actually Mr. Cooper, who I met maybe 10 to 12 years ago. I got hired by a restaurant in Malibu, who unfortunately walked into the wrong lawyer, whose client was a guy who was disabled, whose business was not a real business like you and I have. It was the business of filing lawsuits, wheeling into one restaurant after another, looking for a minor violation of the ADA, only to send a notice to the restaurant owner that they were in non-compliance and please give me $4,000 or $8,000 or $10,000. So I got to meet Mr. Cooper then because he was the insurance person for this restaurant. They were lucky. They had EPLI and they were smart. They had a good insurance broker, Mr. Cooper, who got them third-party coverage on their EPLI policy, so they were protected. That case was resolved pretty quickly, and throughout the years I've met Scott because I represent many, many restaurants who hire me not through insurance, and I find out through the restaurants they have no insurance. I say, you need to get a new broker, and I introduce them to Scott. So really, the most important thing, I'm not a broker. I make no money selling you a policy. I get no residuals, zero. I just care about restaurant owners. I've lived my whole life in Los Angeles, and frankly, I think you need your head examined if you own a business in California and you don't have EPLI insurance. Let me just tell you one quick story, and then I'll get into the 5 points kind of to underscore what I'm telling you. There's a gentleman, Middle Eastern gentleman, he's worked really hard. He's made a lot of money. He's worked really hard in America. America gives everybody an opportunity to do very well. So we had a gentleman work for him in the mid-40s, Hispanic, as a valet attendant. And the restaurant owner says to my friend, client, I've got a problem. The person working for you, I think, is stealing. You need to get rid of him. Okay, so my friend, client says to this gentleman, can't work for me anymore here. I have a customer issue. But I own some restaurants, okay, and because I'm a nice guy, I'm going to give you a job in my restaurant. So, okay, the guy makes $9 right as a valet parker, now he'll make $9 an hour in a restaurant. All right, so he tries it out in the restaurant business, just doesn't work out. He's now 50-some-odd years old, he's not cut out to work in the restaurant business. It's kind of an amazing coincidence that this guy's brother-in-law also works in the same restaurant. He says to the owner, you got to let my family member go. He stinks. What does the restaurant owner do? He lets him go. That's a mistake. If you don't have EPLI, because this is California, he lets them go. What does that mean? Hey, it's time to play the California lottery. Let me find a lawyer, file a lawsuit. Okay, so he files a lawsuit. Now you're scratching your head saying, how can you file a lawsuit, Keith? There's this concept of at will, right? You can let anybody go. And it doesn't sound like he did anything wrong. He wasn't working out well, and his family member said he wasn't working out well. Well, here's how it works. At will basically means nothing. It is a doctrine whose exceptions have swallowed the rule. So here's the way I view it. All right, so this guy looks at himself in the mirror, he says, okay, I've been fired. He meets with the lawyer. I got to figure out a way now how to sue you. Well, I'm Mexican, and everybody that works in the kitchen is Mexican, so I can't say I was fired because I was Mexican. I'm male, and everybody else that works there is male, so I can't say I was fired because I was male. But wait a minute, I'm over 40, so maybe that dog will hunt. So let's file an age discrimination suit. I mean, this is ridiculous. His brother-in-law that works there is over 40. The guy that hired him, my friend the client that hired him twice, is over 40. Why would he be hired when my friend knows that he's over 50 only to fire him 8 months later because he's over 50? The age claim makes no sense. Short story, I'm shattering them in this case. They are going to lose. But as Scott said, we are going to win, but we've lost. Why have we won? Because we've lost. Because it's been 2 years. Sure, I made money, but that's not what I wanted. If there was a reasonable demand at the beginning, the business owner probably would have paid it. He was left with no alternative to fight, and he paid money. So the owner is a loser. Now let me get into the, kind of as a moral of the story is, no good deed goes unpunished. Even if you do good deeds to employees, once they're gone, there's a high likelihood you're going to be sued. And that's with good employees. So let me get into the 5 areas. Number 1, wage and hour. I can walk into any restaurant, I can have blindfolders on, and I can find all your skeletons. It's really easy. So let me break it down between exempt and non-exempt. Okay, non-exempt is the majority of your workers. They're not your general managers, and they're not your executive chefs. It's virtually everybody that works for you. If your employee is non-exempt, that means you must comply with minimum wage laws and you must comply with overtime laws. So I hope you have an employee handbook that you've read, and your employee handbook sets forth what your working hours are and that you pay overtime. I hope you have a time clock. I can't tell you how many restaurants, especially smaller restaurants, refuse to have time clocks. If you have a time clock, it's pretty easy to keep recordation of the hours worked. In the absence of time records, what the employee says he or she worked is going to presume to be accurate. So where I can say most restaurants make mistakes, I can go into many restaurants, especially small ethnic restaurants all over the city, and I know the dishwashers and the busboys, they are paid cash. It's every restaurant's the same restaurant. They're paid $100 for a busboy, $120 an hour, and they work 11 hours a day. You're facing a lawsuit, not only potentially from the individual that's fired if he finds a lawyer, but there's a greater risk. It's the Department of Labor. And the Department of Labor now is just cherry picking who they want to come after. I don't know everybody that's in the audience here, but I'll tell you, if you run an Asian ethnic restaurant in an ethnic area, you're playing Russian roulette. If you're Thai, you're dead. And Scott came, I spoke to 197 Thai restaurant owners about 6 months ago because the Department of Labor has just decided for some political reasons to go first after the Thai business when the Korean or Japanese or every other business is virtually the same. So you've got to properly pay your employees. The second deals with that's minimum wage and overtime. The second deals with exempt. And the funny thing is, if I really wanted to get rich, I'd stop being a lawyer. I'd go work with one of your restaurants. I'd become a general manager. But I know, and you're going to pay me a flat salary of $40,000 or $45,000 or $50,000. And you think merely by giving me a title, I have a fancy title, I'm your general manager, and you think by giving me a flat salary that one or both of those makes me exempt. It does not. There's a test. It's got to be 51% or more of my job duties. I have to use independent discretion. Do I hire and fire people? Do I set the schedules? I mean, the restaurant may be busy. I might do some cooking in the restaurant. I might take some customers that come into the restaurant. So if I'm a general manager that works for you and I'm pretty smart and I keep a good record that I'm doing 50% or less work that doesn't use my independent discretion, you know what I'm going to do? I'm going to work for you for 4 years at $45,000. I'm going to keep a good log of the 12 or 14 hours that I work for you each day because there's a 4-year statute, and then I'm going to sue you. I'm going to sue you for not paying me overtime, and you're going to have to pay me hundreds of thousands of dollars. When you figure out my hourly rate, okay, and it's time and a half up to 12 hours, and it's double time over 12 hours, plus interest, plus attorney's fees, one employee can sink your ship. So I have many restaurants that have the same situation with general managers or with your cooks. Basically, most of your cooks on the cook line, they must be paid overtime. Now, arguably, if you have an executive chef, a true executive chef that goes out and he purchases the produce and he sets the menu, that person might be exempt. Those are the biggest areas. And while Mr. Cooper can help you out a lot, he can get you a sub-limit on EPL policy to give you some wage and hour protection, but it's minimal protection because this is the biggest risk, and insurance carriers know that you're going to get nailed. So really, this is the best thing. You need to do an independent audit, and you do need to have a lawyer that can help you and can walk you through the legal test on exempt versus non-exempt. Now, there's a whole other potpourri of wage and hour problems that I can tell you have. Let's say you have an employee that loses a key or loses a badge, and you say, okay, you have to pay me $5 or $10 for that. Can't do that. That's illegal. When an employee commits an act of negligence in the workplace, you must pay for that loss. If it's willful, then you can charge them. Reimbursement. You must reimburse an employee for all expenses they incur. So if you send somebody out for a delivery, you must pay for the gas for that delivery. If you have a restaurant and you make an employee buy a t-shirt and you have your restaurant's name on the t-shirt, you must pay for that. Okay, we're going to have a seminar in a few weeks that's going to go over greater details, but really wage and hour is the #1 area that you face massive exposure. And then if a lawyer gets a case and there's people that are similarly situated, they'll try to get a class action against you. So even the people that don't want to sue you now can get roped into a class action to get free money. The second area is sexual harassment. This is amorphous. Sexual harassment can also be racial harassment. It can be religious harassment. It's basically the same legal test. Is the conduct severe or pervasive? So as Scott said, sexual harassment is when you have unwanted sexual advances, sexual comments. So when lawyers describe this, it's usually verbal, visual, or physical type of conduct can make up a sexual harassment claim. So let me tell you where I think your weakness is without even knowing you. Some of you don't even have employee handbooks. I don't know why you don't have an employee handbook, but that means you don't have any policy. You don't have any policy with respect to sexual harassment, and if I'm an employee that feels that I've been aggrieved at the workplace, what's my grievance mechanism? It's not in writing. I can say I didn't know or you don't have one, which is probably true. But that's probably not the worst situation of everybody in the room. Because some of you, actually most of you who have employee handbooks, I'm going to guess you haven't read them, and actually if you read them and understood them, they are worse than those of you who don't have employee handbooks. Because as Scott said, I've seen in the restaurant business, most of you don't take the time, you don't take the money, and you don't have somebody that's trained actually sit down with you and analyze your restaurant, your policies, and tailor them to your company. So okay, your sexual harassment policy, some of you may have zero tolerance. That's a good thing, right? Zero tolerance? No way. Zero tolerance is terrible. Go back and read your handbook. Think about zero tolerance. If somebody comes back and watches Seinfeld and comes in the workplace and tells a joke when Jerry's trying to remember the girl's name, and you're, oh, I remember the name, that was a sexual organ. Someone might find that inappropriate. That might be inappropriate. Your handbook says no inappropriate jokes, but wait a minute, your handbook also says zero tolerance. If your handbook says zero tolerance and somebody complained, don't you have to fire the person? I think zero tolerance is a terrible policy. And it's one you would have no employees work for you if you have zero tolerance. And then if you don't fire the person and you have a zero tolerance policy and then you get sued, a good plaintiff's lawyer is going to kill you. I thought this was your handbook. I thought this was your policy. I thought you had zero tolerance. But you let this and this and this go on. I don't know what your answer to that's going to be. Well, I guess we really didn't have zero tolerance. Or zero doesn't mean zero. Zero means 3 tolerance, even though it says zero. I don't know because I didn't read it. Ask my lawyer. All right, go back to your handbook. I'm going to beat up everybody in the room because I know every one of you in the room has this wrong in your handbook. You guys are the owners of your restaurant. I'm going to say, you are the person. I'm accusing you of sexual harassment. All right, no problem. Our handbook's got a grievance mechanism. Well, who are they going to grieve to? Human resources? Your general manager? Does that make sense? You're the owner. I'm the hostess. I believe that you're looking at me. I believe you're touching me. You're asking me out. Okay, I'm going to go to human resources. I'm going to go to the general manager. You're above them. I have a complaint. What are they going to do? They're going to do an investigation and conclude that the owner committed harassment? And does that make any sense to you? So what I'm saying is people have not read they have not vetted their handbooks. That policy makes no sense. Obviously, what you'd have to do is most likely if you had a partner, go to a partner, or you'd have to go to some outside independent, a lawyer or an independent investigator to do that. But I'm telling you, go back home, read your handbook, and think about that instance when the owner gets accused of harassment, if your policy makes any sense. Since I've been doing this for so long, I know where the Achilles heels are. So shore up your handbook. Everybody should have a good new hire packet. New hire packet. Good standalone at-will document. Good standalone arbitration agreement. Sexual harassment policy. And everybody signs that when they're hired. A receipt and acknowledgement that they've read and understood the employee handbook. I can't tell you how many restaurants I see that have in English receipt and acknowledgement. If you know a large portion of your workforce doesn't speak English and can't read English, why would you have them sign a receipt and acknowledgement in English? That makes no sense. So if you have a handbook and you have people that speak Spanish, make sure that it's in Spanish. If people speak Thai or another foreign language and you know they can't read English and you actually think the handbook means something, then have it translated into the appropriate language. Next area, wrongful termination. I have this third, and I have this down minimally because I'm dealing with your business. There's this legal concept called the duty to mitigate. So the truth is, if I work for you in your restaurant and I'm a hostess, a waitress, a busboy, you know, any 96% of the positions in your restaurant, and you fire me, it's really not a big deal. Why? I can go down the street and get another waitressing job or another busboy job or another dishwashing job. Okay, and the reality is people in those positions are not looking to sit on their butts hoping to hit the lottery. You know, they have families to feed and they are hard workers. So they're likely to go within a week and get another job at the same pay level. So really their loss of income is relatively minimal. So I have the wrongful termination down smaller than the first two things I gave you, but it is a concern. As I say, one employee, if they want to sue you, can cause you a lot of grief and a tremendous expense. So I will give you this pointer. The number one area I see of wrongful termination suits occur, and it's this amazing coincidence, when somebody asks to go on a leave, workers' comp leave, pregnancy leave, some kind of a leave, all of a sudden the business owner has an epiphany that now it's time to fire that employee. That employee was a bad employee, he was a bad worker. Well, why didn't you fire that person a day before they asked for leave? That doesn't make any sense to me. It sounds like to me you're firing them because they took a leave. And then let me see the personnel file then. They were so bad, how many times were they written up? None. If you can avoid firing people when they're on leaves, I think you'd eliminate 50% of the wrongful termination suits. Second thing, whenever you have to fire somebody, do it with dignity. Do it with dignity. These are human beings. I don't care if the person stole from you. You sit down with the person, you thank them for the work they did for your restaurant. They know they made a mistake if they really stole from you. We all make mistakes, even though it's a bitter pill to swallow, right, to say it. We all make mistakes. You're not looking to crucify the person. You're wishing them well, and that's it. If you treat him like a man, and he knows he stole from you, most likely to look on. You start calling the police, the DA's not going to file anyway. And I don't know why you would call the police. Those are the two things I can tell you to avoid most wrongful termination lawsuits. I told you about this arbitration provision. Everybody should have an excellent arbitration provision. The 12 people sitting on your jury hearing your case are not business owners. So if you have a choice of having your dispute heard, somebody wants to win the lottery because they missed 1 week of work, or they could have found a job down the street, 100 jobs, you would rather have an arbitrator any day hear your case. But you have to have magic words. There's a case called Armendariz. You have to have magic words in the arbitration agreement in order for a court to enforce it. That's a very, very important document that a lawyer can provide for you. Next area number 4, disability claims. You should look at your agreement you have with your landlord. So as I told you, there's guys that go up and down looking to sue restaurants, the Trevor Law Group. This is years ago. I try to help out the Thai community a lot, that people trust me. Years ago I did this pro bono. The Trevor Law Group was looking to shake down. They were going by Asian group by Asian group, and they went after the Thai restaurants. Okay, these are very, people are trying to make money, restaurant owners living on the margin. You can't sell pad grapau for $6.95, $5.95 and make a lot of money. Okay, these are good, hard-working people, and so they would go down, you find a minor violation, you don't have 2 bars of soap, or the rack in the toilet is low, send a demand letter, give us $1,000. All right, if you send to every Thai restaurant, give me $1,000, and you have 500 Thai restaurants, it's going to cost you a fortune to hire a lawyer. That's pretty good money, right? At 50% pay you settlement money. Actually, these lawyers end up getting disbarred. So these types of disability claims, Scott named them, they can be covered under third-party claims. Of course, there's different types of disability claims that I'm not talking about today. On the 5 major lawsuits, you can have a disability claim by an employee. If you have an employee that's disabled, you have to make a reasonable accommodation. You have to engage in an interactive process. Also, as a sidelight there, if you have an employee that asks, let's say you have a Jewish employee, and they ask to take off for the Sabbath, you have to attempt to make a reasonable accommodation to give that employee the time off, even if it's a non-traditional religion such as Wiccan. So I put as a fourth category disability claims. Let me go back to what I said on the indemnity agreement. So if you think about it, you have this claim. Maybe you have insurance for it, maybe you don't have insurance for it, but you're saying, why is this my headache? I'm just a tenant. I don't own the building, it should be the landlord's. Go back and read your agreement with the landlord. I can't tell you how many I've seen where the landlord tries to shift back to you as the tenant the obligation to indemnify the landlord in connection with a suit like this. This is something you're free to negotiate when you're negotiating a lease agreement. The fifth area I wrote down, this is discrimination by customers. Again, would be covered under third party. I don't know if you've been seeing this recently, it's strange to me. Employees have been writing on receipts racist comments. There was a comment at Chick-fil-A, Ching and Chong, at Landmark Steakhouse in Newport Beach. There was an African-American customer, and the bartender made derogatory racial comments. In a restaurant in a casino in California, 3 customers were called fat. In New York, in a Papa John's, on a receipt, lady chinky eyes. Okay, of course, a business owner wouldn't condone this stuff, but you guys know, you're not at the restaurant all the time. You don't see what everybody puts on receipts, right? It's one silly, foolish, childish, or racist employee that they can wreck your world. Really, they can't wreck your world. And without the insurance, you're going to have to find the money to pay for it. So these types of claims I put under discrimination claims by customers. There's also another subset of claims now, Prop 65. There's a lawyer who has a friend from high school who he's going around. The guy's an artist. So he just goes around restaurant to restaurant. I think they just sent out 67 demands already. The guy likes to eat out a lot. Saying, you have to say chemicals, Prop 65. You have to have an adequate posting to inform what's in the food. So without the right Prop 65 warnings, the lawyer sends a lawsuit, again, trying to shake down the restaurant owner. Again, if you have the proper EPLI, this would be covered. So, just to summarize, no good deed goes unpunished. You face a threat from every employee, even those employees that you've been good to. EPLI, it's a few $1,000s. And when you write it off as a business expense at the end of the year, it's peanuts. And I would get $1 million worth of coverage, and you will sleep better at night. I mean, I can't give you any magic words. You are going to be sued. It's a game of Russian roulette. It's just a matter of time. You haven't been sued for 10 or 15 years. It's going to happen. Okay, it was nice meeting everybody. I hope I gave you some comments to help you in your business, and I'll stay after.